Okay, good afternoon. My apologies for getting a little late start. This is actually Lecture 15, Legal Studies 160, Punishment, Culture, and Society, taking up the topic of life without parole, which some have called the new death penalty. And sort of we'll finish off our study of the death penalty with this and segue to the study of imprisonment. Life without parole, or essentially a sentence to die in prison, might be viewed as the ultimate sort of synthesis of those two penalties. In any event, I'm going to turn to that in a moment. Before I do, I just want to ask if there's any follow-up questions or thoughts about our discussion on Tuesday of capital punishment in Asia. Please.
I feel one of the factors you may not have explored may have been political backlash, because especially, I mean, I'm also familiar with my case in Korea, where, symbolic enough, the last person to be executed was a political prisoner who was supposedly a spy from North Korea, and as soon as the new party, the Democratic Party, the left side, the left wing came to power, all the executions were kind of stalled because there was the whole pressure that people who were in death row were kind of politically biased against. So I feel like in these countries where there have been a drastic transition of power, maybe those kind of things factor into it as well.
Which kind of things?
So, for example, like in Korea, the right-wing party traditionally have been associated with the military dictatorship of the 70s and 80s. So when the death penalty became questioned in the late 90s, a lot of people were saying that, well, people were definitely in there not because of any crime, but because of the political bias against them by the military dictatorship. So that now the Democratic government should not execute based on the fact that...
That's right. Well, in that regard, I mean, and this is something that Frank Zimmering, I think, argues or Zimmering and Johnson, David Johnson and Frank Zimmering, they intimated in the short piece I asked you to read, but they developed it at greater length in their book. And it's the European case is laid out in the chapter of Zimmering's earlier book on the death penalty that I asked you to read. But what you're describing by Korea very much would seem to follow the pattern that we saw in Europe of complete abolition of the death penalty happening at a moment of significant political liberalization, either the move at what we might truly call transitional justice or jurisprudence from an authoritarian or totalitarian government to a democratic rule of law one, or even in the case of the French Fifth Republic, a shift from a traditionally dominant right-wing party to the first time the left comes to power. In the case of France, the left, as Europe had for a long time, saw the death penalty as kind of a pivotal issue of resurgent liberalism, if you will. Now, the Korea case fits that very well. You've got not only a true transition from authoritarian to democracy, but as you point out, I mean, you're moving from a system that relies on execution, if not exclusively for political prisoners. I mean, there are probably some ordinary murderers or other criminals that are executed by the military regime. I don't know that they did, but certainly many of the people executed were for political dissent reasons. And as you point out, the very last execution apparently was of a political prisoner. The South Korean democracy leader himself having been under sentence of death. Very dramatic. So the real question is whether, is the other shoe going to drop? So we've had a moratorium in Korea, but we've now had over 10 years of the new regime. And the question is, does that new regime have legitimacy or political strength to finish the abolition process? The farther you get from the moment of democratization, in some ways, the less the kind of sense of enthusiasm for shedding the ways of the old regime carry over to getting rid of the death penalty. We see that in a number of countries, South Africa, Romania after the fall of the Ceausescus. There's a kind of identification of the execution system with the old regime, which makes it much easier for politicians in the new regime essentially to remove the death penalty as part of the larger removal of the archaic implements of rule of the old regime. Now the problem is, the longer democratic politics goes on, you get what you get in the United States, which is a new kind of support for the death penalty, one that doesn't come from traditional authoritarian sources so much as from populist concern with victims and fear of crime. It was interesting in Taiwan, which also had something of a transition to democracy, both a dramatic kind of transitional one from authoritarian to democratic, which is some years ago now already. And then in 2001, the shift from nominally democratic but still one-party rule, essentially, of the Kuomintang to the Democratic Party looked like you should have a significant movement toward abolition. And indeed, the justice minister that came in with that government was quite keen to abolish. But there was populist resistance to it at that point. And indeed, I posted the article on the Taiwan situation, but it points out that one of the major opponents was a Taiwanese pop star whose, I think, daughter had been a murder victim sometime earlier, and who kind of became very much the popular proponent for supporting the death penalty, for keeping it going. So it's an interesting pattern. China would be the most dramatic possible example of that. If we did see a transition to some kind of fuller democracy there that really wanted to underscore the transition as opposed to the continuity. And of course, depending how that transition happens, there may be more continuity or change. The new regime, if there is one, may choose to use the death penalty and its abolition as a way to underline the difference in the kind of government. But they may choose to continue what they already have, which is to some extent a sense that the death penalty is a way to appease popular anger about crime and local corruption, etc. Other thoughts or questions about the Asian death penalty? Yes? Well, as I say, it's very murky. I'll have to ask Bob Baring, who teaches a very excellent Chinese law and legal history course here in legal studies, had mentioned this kind of link between organ donations and executions. I mean, two things to say. One, this should remind you, before you kind of jump to the conclusion, Asian values versus European values or something. Keep in mind that a big engine of the English death penalty was the need to have bodies to dissect, as we saw. So this is actually a very old practice. There's certainly a fair question as to whether it's an additional form of degradation that may be viewed as a kind of holdover of degrading punishments, or whether, as you suggest, it sort of could be seen in a more modern light, especially if the inmate is given some voluntary, what we might not consider voluntary, but at least some symbolic consensual role or incentive. So there's that kind of continuity with and the sense that could create, as it may have in Edinburgh in Scotland, where the doctors at the very, very kind of importantly growing new medical schools needed those bodies and may have put additional pressure on the crown to produce more executions. We might fear that in countries like China, where there's wealthy people and a market, maybe pressure for a market for things like organs, that could, and there have been accusations, frankly, that particular executions in China were picked out, where the person was chosen at that time because they had a match with somebody who needed the organs, etc. The other side of that, of course, is this is a major vulnerability for the Chinese regime in terms of the international human rights discourse. I think China will want to go a long way to put to bed claims that it's doing this, and I would suspect how they'll find other ways to get organs. Of course, the same problem we face. We have quite a low rate of organ donations. I don't know how many of you checked the little box. I think when I first came to California was when they first let you put a check on the back of your driver's license indicating your readiness to make an organ donation. I always wrote, make sure I'm dead next to the check. But still, far too few people do check that. So that may create some pressure for maintaining it in China. But again, to the extent that the Chinese want to keep the death penalty, as we go in the transition may not be as the same pace. But I would predict that as in the United States, you will see efforts to strip the death penalty of its more controversial and degrading features. In some ways, the safest death penalty for China to defend would be an American-type death penalty, where it's very rarely used. It's used at least symbolically, mostly against seemingly especially frightening or unpopular criminals, and where there's a kind of, at least the gesture of a lot of due process protections and protections of the dignity of the victim, which you clearly don't have at the moment. Okay, well, let's talk about the new death penalty, right? Because if you buy my argument, sort of perhaps a version of Garland's and Zimring's, etc., America isn't so much off on its own divergent path of retaining the death penalty, while at least its typical peer countries, fully developed democracies, whether Japan, which still has a death penalty like us, but more poignantly Europe, which does not. In fact, we have a death penalty that already is quite abridged and abbreviated, reflecting in some ways many of the same values and political forces that have ended the death penalty elsewhere. And now, at least I would argue, the death penalty is kind of limping on, and its end is at least imaginable. We can imagine, as we talked about the other day, even a Supreme Court of the United States ultimately saying the death penalty is so limited geographically that it's finally cruel and unusual in a constitutional sense. But even as that slow transition takes place, I don't know how long it will take, we have to note the fact that there's in some ways a new ultimate sanction that is taking its place, and that is life without parole. And the question I asked for this class was, will the end of the death penalty mark the beginning of life without parole as the new ultimate sanction? And in a certain sense, of course, the answer to that is obvious, right? It must. If currently the most serious and therefore ultimate sanction is death, and the next one on the menu is life without parole, and as, for instance, the California voter initiative that will probably be on your ballot in November eliminates the death penalty and replaces it with life without parole, then by definition, life without parole becomes the new ultimate sanction. And yet it's already a very different ultimate sanction, not just in the fact that the state does not willfully cause someone to die in a life without parole sentence, although the state maintains control of the person until they die, but it's also different in the scale, right? The death penalty, despite a kind of surge in executions and death sentences in the 90s, remains a very tiny and now decreasing sanction, going from symbolic to kind of purely almost just a vestige of itself. Far from true with life without parole. It's not only involves a lot of people, but it's growing fast. And I would argue that as a sanction, it's actually gathering other sanctions toward it. That is, some sanctions that are, for instance, life with parole, are beginning to look more like life without parole in many states as parole becomes rarer or takes place after many more years than it used to. And the numbers are significant. As of 2008, according to the article by Michael O'Hear that I put up on the web and put up on the website and called to your attention, as of 2008, there were 41,000 inmates in the United States serving life without parole sentences. And I'll try to define in a little bit more precision what exactly a life without parole sentence is in a minute. That's 3 times the number in 1992, right? And that's despite the fact that crime has gone down very significantly nationally, including homicide, since 1992. And this compares, the overall 41,000 inmates compares to around 3,000 or less than 3,000 on America's death row. So while this may be an ultimate sanction, in a logical sense, it's replacing the death penalty at the top of the menu as the most expensive item, in effect, the most severe penalty. It's already, from a social point of view, it's a different beast. It's a bigger deal. And the reason that some of us, myself at least, who are concerned about the overall excessiveness of punishment in the United States, feel a little nervousness about the end of the death penalty is not that we don't, at least in my case, don't favor eliminating the death penalty. It's a concern that as the death penalty is being eliminated, we seem to be embracing a penalty that is very, very severe, historically speaking. I'm not going to get into it right now, whether we consider it more severe than death or not. That's an argument that's been going on since Beccaria, but it's a very, very severe sanction. As I'll show you in a moment, it's much more severe than what we used to do with people that we didn't execute if we convicted them of a crime for which they could have been executed. So overall, it represents an increase in the level of punitiveness. And as we get rid of the death penalty, it may become even more tempting to put more people in that box. That is, even if LWOP remains in a box labeled capital sentence or aggravated murder, that it's in a special place that not say all murder convicts are vulnerable to, even if that's true, we have to assume it'll be much easier for prosecutors and juries to hand down that sentence than it is a death sentence. Death sentences have a lot of resistance. It's not easy to kill a person, even sentence them to die. And indeed, if you study how the death penalty works on a micro level, you'll see that prosecutors have a heavy burden, even in cases of gratuitous and heinous crimes, ultimately convincing a jury to play a role in putting someone to death. Once you take that away and you're saying they're not being killed, they're just being put in prison for life without parole, we can imagine that this is going to get bigger and bigger. Now, the status of life without parole is sort of back on, is getting attention, probably at a time when death penalty opponents would prefer that it not, right? Because people who want voters in California to adopt the initiative that would eliminate the death penalty in favor of life without parole would rather delay, probably for some time, a conversation about whether life without parole is itself a problematic and unacceptable sentence. If it isn't, getting rid of the death penalty doesn't seem like it's going to end the debate, just kind of move it. In any event, a case in front of the Supreme Court this term, which may get decided, typically will get decided this spring, maybe after our class is over, but in June. It focuses on life without parole for a specific set of convicts, that is people who were minors when they committed the crime. And for reasons that you can imagine in terms of how lawyers choose cases to fight these battles, the 3 cases, two prisoners whose cases have been joined in the successful appeal, successful in the sense of getting an appeal heard by the Supreme Court, are both under 14, or I should say were both under 15 at the time, 14 or under at the time. I think they were both actually 14 at the time that they did their crimes. They're a bit older now, obviously, since some years go by between when you do a crime, when you're convicted, let alone when the appeal comes. Now, this young man, Dakota Eliason, was the subject of the New Yorker article that I had hoped that you would be able to read. They've got a fancy new paywall up, so unless you're a subscriber, you will not have been able to. But in any, and I'll tell you a little bit about his case. But it very much has, the New Yorker covering an issue in their Annals of Justice section is a sort of good indicator that it's kind of up for cultural discussion, right? The New Yorker is not a law journal; it's to some extent a journal of culture, and so it may not be representative of our overall culture. It certainly biases liberal and elite, but it is nonetheless an indicator, if you will, that this question of life without parole is sort of up for debate on a cultural level. A license case is, I think, not untypical in some ways of very young people who get the death penalty. And it's not the death penalty, life without parole. And it gives me a chance to tell you a little bit about how it works in some cases. Now, you know already from our discussion of the death penalty that one way you can get life without parole is by being charged with a capital crime and the jury deciding not to give you the death sentence, in which case life without parole is often, in many states, the mandatory alternative. They have no real choice. In cases like that of Dakota Eliason, because he was a juvenile, first the judge had to decide whether to try him in adult court at all. He could have been tried in juvenile court. Had he been tried in juvenile court, which generally has jurisdiction over people up until they're 18, but in most states now allow either judges or sometimes prosecutors to choose to put a juvenile in adult court if their crime is serious enough. And this was a homicide case, which I should mention. Dakota Eliason shot to death his grandfather in the middle of the night in an episode that's never really been fully explained either by him or anyone else. He hadn't just been beaten by his grandfather or anything. They actually had a fairly good relationship. As I'll mention in a little bit, a lot of bad things have been happening in his life. His grandfather kept a gun in the house. He took it and he shot his grandfather to death. His father, whose stepfather, but who had raised him, was the victim, has kind of stood by him, as his family has, although during the police investigation, the father actually played a role in helping to secure his confession. It's something that happens in a surprisingly large number of cases where juveniles are charged with a serious crime. They actually have a legal right to have their parents present during questioning, as well as a lawyer present during questioning. Having a lawyer there is a really good idea if you want to avoid the worst penalties. Having your parents there, not such a good idea, because even when you haven't just killed their parent, but they often tell you to cooperate with the police and things of that nature rather than look out for your legal interest. In this case, the father got quite emotional in an exchange that helped to lead to a licensed confession. In any event, there's no real question as to his guilt in the sense that he doesn't deny that he did the shooting. The real question is what should happen to him. The judge decided that the crime was so serious, and because, according to the judge, he seemed to be unremorseful, which is an interesting judgment about his psychological attitude about the crime. But the judge basically has discretion. They can decide whether this person goes to juvenile court or adult court. And in this case, in many cases, it doesn't make that much difference. There have been lots of studies actually showing that when juveniles are sentenced in adult courts often will use juvenile sentences anyway, and so it's often not a very big deal. Here it was, because even if you're convicted of murder in a juvenile court, and it wouldn't be technically murder, you'd be found to be a delinquent in need of state care. The most you could be held for would be until you were 21. So in the case of Dakota Eliason, that would have been 6 years. The contrast, if he went to adult court, he was facing life without parole because they don't have the death penalty in Michigan. Of course, he would be too young for it. At his trial, and I posted on, I could not post for you the New Yorker article because it's basically unobtainable unless you've got the subscription or pay for it. I did post up on BSpace an article from the Niles Daily Star, which is the local newspaper in Michigan where this happened, that's describing Eliason's current legal efforts to overturn his life sentence. He's in essentially collateral appeal, where you're basically claiming that your lawyer gave you ineffective assistance of counsel. The benefit of that is that it allows a court to look more at the underlying evidence that the lawyer could have developed but did not, whereas in a straight appeal, you're only looking at what was presented in court. And you can see from these quotes that basically come from a reporter's description of the evidence being presented at this new hearing, that the kind of claim that the prosecutor made that was obviously accepted by the judge in the case of Eliason is that Eliason was basically a sociopath, that his calmness, witnesses, including the police, his father even, were all noted the fact that he seemed extremely calm and he wasn't emotional, didn't get upset, except finally after he did the confession with his father's prompting. The prosecutor took this as evidence that he's basically a sociopath, a kind of monster that has no conscience. If you have no conscience, then you kill somebody who doesn't really bother you very much, and you don't evidence the kind of upsetness that even other people who kill might. The evidence that the lawyer didn't present, but which his current lawyers would like to present if they get a new trial, suggests that he was, in a sense, suffering from post-traumatic stress disorder. He had suffered a series of traumatic events, including his biological mother giving up her parental rights legally. He was in the custody of his father, but his biological mother still had parental rights, which she then essentially abandoning him. The death of his dog, the suicide of a close friend, breaking up with his girlfriend. Again, he's 14, and his family losing its home contributed to the symptoms of this, what is described in the testimony as being almost a kind of fugue state killing where you're kind of watching somebody else do it in your imagination. Now, the merits of that are beyond our concern today. I just wanted you to get a flavor. You might be thinking, how does a 14-year-old get sentenced to life without parole, right? And in a crime that might seem a little bit less alarming to the public because it involves a family member and there's not an angry victim's family demanding retribution, etc. And this is just a taste of the kind of logics. Well, let's ask, I think, an important, what I want to do with the rest of our time, having kind of suggested to you that life without parole is actually a new kind of penalty. It's not the death penalty, and it's a little bit different than the kind of life sentences we've had in the past, and I'll flesh that out for you. I want to now ask sort of several more questions about, is it really new? What's motivating its adoption in the United States and its spread? How representative of the rest of the world are we? Is this another example of the U.S. being kind of on its own tangent, or is this something that has legs? And finally, how stable is this? Are we going to end up with life without parole lasting another couple centuries like the death penalty did? Is it likely to be successfully challenged on constitutional grounds or abandoned for other reasons? So the first point is it new? And still on the theme of sort of what to make of it as a distinctive penal sanction, I want to think with you about Durkheim's quantitative and qualitative laws of penal evolution, right? He had said that over time, penalties tend to get qualitatively sort of less degrading, less painful, more respectful of the sort of dignity, if you will, of the individual person being punished, and also quantitatively less severe. Fewer people punished for less severe penalties over time. For the qualitative part, for Durkheim, the main thing was to shift from the death penalty to prison. From the quantitative part, he was looking at what he thought was some decline in the overall severity of sentences to prisons or to exile or to forced labor. So as we think about life without parole, qualitatively, it does meet Durkheim's law of penal evolution. It compared to the death penalty, which it to some extent replaces, although it's obviously over-supplementing that replacement by pulling a lot of cases that would not have gotten the death penalty. But quantitatively, it does not, it seems to me, at all fit the model of a sort of declining quantitative severity. So how did we get a life